Welcome back to the deep dive. Today, we're tackling a piece of legislation that's really generating a lot of discussion. We're talking about the Constitution, 130th Amendment Bill, 2025.
That's right. It just cleared the Lok Sabha, India's lower house of parliament, and now it's gone to a joint parliamentary committee for, well, a deeper look.
Yeah, exactly. So our mission today is to, break down this bill, really understand its core provisions, and explore the pretty significant questions it raises for our constitutional framework.
Uh-huh.
Okay, let's get into it. So maybe start us off. What's the kind of central idea behind this bill?
Well, at its heart, this bill is trying to prevent ministers from actually governing while they're in custody.
Okay.
But what's truly significant here is just how broad its scope is. It's quite sweeping.
How broad are we talking?
We're talking everyone from the prime minister,
Hmm.
chief ministers, all the union and state ministers, and even those ministers in union territories, like Delhi and J&K.
Yeah.
It really casts a wide net.
Right, comprehensive. And the mechanism for removal, that's quite specific, isn't it?
It is very specific. The bill basically states that if any of these ministers are arrested and then detained for 30 consecutive days.
Consecutive, okay.
Yes, consecutive days. And crucially, it has to be for an alleged offense that's punishable with 5 years or more of imprisonment. If that happens, they automatically lose their post on the 31st day.
Automatically. So not much room for discretion there at that point.
No, it's framed as an automatic trigger.
And who actually does the removing? Who enacts this?
Right. So for union ministers, it would be the president acting on the prime minister's advice. For state ministers, it's the governor acting on the chief minister's advice.
Okay.
And this is notable for the chief ministers themselves. The governor would act directly.
Directly. Interesting.
Yes. And this, of course, means amending key parts of the Constitution, Articles 75, 164, and 239 AA. These are the articles governing how ministers are appointed and, well, how long they stay in office at union, state, and UT levels.
Makes sense. And what if they get bail later?
Well, the bill does allow for reappointment after release on bail, but that's purely a political call, up to the executive.
Right, right. Now, this really feels like where it marks a truly significant shift from how things are now. How does this compare to our current laws?
Oh, it's a huge departure, a really big change.
How so?
Currently, under the Representation of the People Act, 1951, the RPA, as it's known, a legislator is only disqualified after they are actually convicted of certain offenses.
After conviction. Okay.
Yes, they can hold office right up until that judicial finding of guilt. But this bill, it lowers that threshold quite dramatically. It shifts it from conviction down to just the act of arrest and detention for 30 days.
Wow. So that's a fundamental shift, isn't it? Because arrest is, it's part of the investigation, not a guilty verdict.
Exactly. It's pre-trial, pre-conviction.
Is the government framing this as like addressing a gap that needed fixing?
Absolutely. I mean, the main push seems to be tackling these situations where ministers have continued running things from jail. We've seen recent high-profile cases like Senthil Balaji or Arvind Kejriwal that have, sparked a lot of public debate.
Right. Questions about efficiency and trust.
Precisely. Questions about executive efficiency, public trust. So this bill seems to be trying to redefine that trust, moving it away from just a final court verdict.
Okay, so for such a major change, what's the government's core argument? What's the main rationale they're putting forward?
Well, the primary rationale is presented as curbing the criminalization of politics.
Yeah.
And also upholding something often called constitutional morality, the idea of high ethical standards in public office.
So the argument is that ministers need to be beyond suspicion.
That's the government's line, yes. That ministers, as public representatives, must have a character beyond suspicion. And they argue that allowing them to govern from jail just erodes public trust and, frankly, hampers the executive's ability to function efficiently.
And I heard they've tried to put this in historical context, too, contrasting it with other amendments.
They have, yes. Proponents have drawn a contrast, for instance, with the 39th Amendment during the emergency period. They suggest this bill actually does the opposite. It aims to bring leaders squarely within the law's reach, not place them above it or give them immunity.
Okay. But of course, an approach like this is bound to face pushback. What are the main criticisms, especially around things like due process and federalism?
And that's really where the debate gets heated. A major, major concern is the presumption of innocence.
The innocent until proven guilty principle.
Exactly. Critics argue this bill effectively triggers removal, kind of punishment, really, before any trial or conviction,
Yeah.
just based on an accusation and detention. That fundamentally alters a cornerstone of our justice system.
And beyond the impact on the individual minister, there are fears about how this could be used politically, right?
Absolutely. There's a very real fear of, well, political misuse. Well, think about the investigating agencies. They are sometimes, let's be honest, accused of political bias. Critics worry these agencies could potentially be sort of weaponized, used to deliberately destabilize opposition-led state governments.
But just ensuring an arrest lasts 30 days.
Precisely. Orchestrate an arrest, keep someone detained for that crucial 30-day period, and trigger their removal. It could certainly create significant federal tensions.
And that specific power for the governor to remove a chief minister directly. That sounds like it could be a real flashpoint for state autonomy.
It definitely is. That particular provision is raising serious alarms. It potentially undermines state autonomy and federal principles because it gives the governor who is appointed by the union government direct power over an elected chief minister, bypassing the state legislature in that removal process.
Wow. Okay, that is a lot to unpack. A really complex and pivotal debate shaping up here. The Constitution, 130th Amendment Bill, 2025, it clearly has this aim of cleaning up politics, maybe curbing criminalization. But it also, as we've heard, sparks these really crucial discussions about individual rights, the very core of due process, and the delicate balance of power in our federal system. So as you reflect on this deep dive, maybe consider this. When the goal is ensuring integrity in public office, which is important, how do we best balance that with the fundamental principle that everyone is innocent until proven guilty? Where exactly should we draw that line? Definitely something to chew on.